Good morning, everyone, and Happy New Year to you. Welcome to today's webinar, a very popular and important topic, what families need to know about planning for a loved one with special needs, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's event. So how this will work today, if you're new to our webinars, if you are, welcome. We're glad you're here. And if you're coming back to see us again, thank you for being here as well. So you as the attendee are in listen-only mode. However, if and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we'll take time throughout to address them. Your questions really help the presentation and add value. They help others learn. So please don't be shy in posing your questions at any time. You received the presentation yesterday by email for me to take notes on it if you wish. If for some reason you did not receive the presentation, it is available in the section marked handouts in the panel on the screen to download at this time. For our advisors, for CFPs, CPAs, and various other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. Per my attendance records requirements reporting, please email me your ID number, and for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval. Everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please take just a couple minutes to fill out the simple survey to offer us your feedback about the presentation. And it's also an ideal time to request a consultation with Steve for any planning needs that your family and you may have. And we always look forward to being a resource to you here at Elville and Associates now and in the future. It's a new year. If you've been putting off planning, now's a great time to think about setting that free consultation with us, and we'll be happy to be a resource to you, as I mentioned. So briefly, I'd like to offer you an overview about our firm and share a little bit about Steve, and then we're going to jump right into it. So a little bit about Elville and Associates. Let me jump back one screen. We were founded in 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville. We have a number of different practice areas here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 7 attorneys, 12 staff members in 5 locations. We're coming to you live from the Columbia Gateway Community location here in Columbia. Steve and I braved the weather to get here today so we could be sure that the wireless connection would be good for you all today. And our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. We do offer a lot of education here at the firm, and we do that in a number of ways. We offer it through our planning processes with our clients. We offer well over 100 educational webinars and workshops in the communities we serve each year. And we also offer it by way of our accredited client care program, or CCP as we call it. We're one of only a couple firms in Maryland to have an accredited CCP through the Client Care Academy in Boston. It's a robust set of benefits that we offer. Many of our clients take advantage of. If you'd like to learn more about it, please let me know, and I'd be happy to share a lot about it with you at another time here. So just email me or give me a call here at the office, and I'll be happy to talk to you more about our client care program. Steve Elville. His work as an attorney the past 20+ years has been centered in elder law, special needs planning, and estate planning with an emphasis in the areas of tax planning and asset protection. He is a member of a number of different national organizations, the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. Very important, he works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. He is a very seasoned speaker. Each year presents at many webinars, workshops for businesses and their employees, conferences, and continuing education events. Also named to the Maryland Super Lawyers list for a 7th time in 2022 and a 6th consecutive year. So congratulations to Steve. And also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, our firm's charitable organization he founded in 2014. And I'm very privileged to be the executive director of, which keeps me busy as well, along with my job here at the firm. And if you'd like to learn more about our charity, please reach out to me. I'd be more than happy to share our story and how we work to make a musical difference in the lives of children every day that want to participate in music but may not have the means to do so on their own. And that's where we come in to try to make a difference. So a little bit about our firm and Steve. We're going to go ahead and get started with the presentation. Before we do that, we're going to launch a quick poll to get to know our audience. So to get to know our audience, we're going to ask, what has brought you to today's webinar? And the choices are, I need to set up planning for a loved one with special needs. Second, I have planning in place, but it needs to be revisited. Third, I'm a financial advisor here to learn to better serve my clients. Or fourth, I'm an interested family member here to gather information. So let me just take a minute to choose the selection that best suits your situation. We always like to know who we have joining us today so we can tailor our presentation to our attendees. And we'll just take about 15 seconds to gather that information. All right, looks like all those who want to vote have voted. So with all the responses coming in, 35% say I need to set up planning for a loved one with special needs. 43% say I have planning in place, but it needs to be revisited, which is not uncommon. 9% say I'm a financial advisor here to learn to better serve my clients, which is always great. 13% say I'm an interested family member here to gather information. So thank you for participating. We appreciate it. I'm going to go ahead and turn the presentation over to Steve. So Steve, you should see the button pop up to make you the presenter.
All right, thank you, Jeff.
I'm going to close out the poll there. There we go.
All right. And I'm waiting for that button to pop up.
Okay, let me go ahead and resend that. There we go.
There we go. Very good. All right, and I'm now going to share my screen and get my presentation going here. Here it is. And Jeff, you should be able to see that. I hope so. All right, so Jeff, could you confirm that you can see my screen?
I do. Looks good, Steve.
Thank you so much. Well, good morning, everyone, and thank you. And it's Happy New Year to all of you on this snowy Friday morning, and we thank you for taking the time to be here and share your morning with us. And I know those of you on this webinar, especially the vast majority of you, have needs for education and understanding what your next steps are for special needs planning, whether it's to get an initial plan into place or to update an old plan. So I thank you for being here. It's my privilege to not only lead Elville and Associates, but also to be involved in the special needs community and to be here this morning to teach you and to lead you through a discussion. I want to thank Jeff for his wonderful introduction and for all of his hard work. Without Jeff, I could not do these webinars and do what we do here at Elville and Associates. So I thank Jeff. And I also want to remind you of what Jeff said. He is a very capable moderator. Jeff will lead you through questions that you can then pose to me if you want to send those questions to Jeff. We're here to have a very informative but informal type of presentation where you can participate. So if you have questions, please let Jeff know, and we will stop occasionally as we go through. So we have a lot to cover, and I'm not going to linger very much longer, and we're going to get right into the presentation. But I want you to know that this is a lot of information. If you have not seen this presentation before, don't be overwhelmed. There's a lot to know. There's a lot to think about. There's a lot of choices, but we're going to give you this presentation as a tool. And I know you have the handout, and if you don't, Jeff will make sure that you have it. We want you to have time to think. We want you to not only learn, but we want you to have a path forward. So we are big believers here at Elville and Associates that education is number one. Client education and continuing education, not only of yourself, but of your family members. That's number one. But also making sure that clients have a path forward. So we want you to be able to formulate your questions, come in, be able to ask those questions, be able to become educated, and not only learn, but to go from point A to point B to get the planning done and get it in place. And not only that, but to get it funded with assets either now or at the time of your death in the proper way. So we want to make sure that all of those things happen and that we just don't get stuck in a cycle of education, but also action. So with that said, I'm going to get right into the presentation, and please let us know if you have any questions, make plenty of notes, and here we go. All right, so why do we plan for a loved one with special needs or with a person with disabilities? Well, it's really to enhance the quality of that person's life. And most of you on this call have a loved one with disabilities, and you know this much more than I do. You know what you're dealing with, you know what you're doing for your loved one, and you know what your concerns are. And this is a good time to stop and think that all planning is goal driven. So as we think about why to plan, well, it's not only to enhance the quality of life of the person who we're trying to help, our loved one with disabilities, and to not restrict their potential and to maximize their lives, but also for your own planning reasons, for your own emotional reasons. I want you to have a goal and to understand why you're planning. So the benefits of planning could include, and do include many times, providing financial security for our loved one, leveraging means-tested benefits. So some of you understand the basics of means-tested benefits, but this is something that we're going to drill down into more today. I don't expect that you're going to learn it all, but it's something that all persons who are doing planning should understand, and all of the trustees that are involved to carry out your planning, they need to understand this. We want you to have a proper team of advisors. I find that many families with a loved one with special needs, they really could use an advisory team, meaning not only an elder law or special needs attorney, but a financial advisor, a CPA, and in some instances, an insurance specialist. So we want to help you have this team. It may seem like a lot to undertake. We're here to help you to understand the kind of team you should have, and we're here to help you form a team if you don't have one. And yes, these things sometimes come with a cost. For example, the cost of professional advice, the cost of professional services. But I'm going to lead you through this discussion with the idea that we want to shoot for the highest and best practices. So we want to have an advisory team. Many of you are concerned about appropriate housing for your loved one, whether you're going to leave your particular residence in a further trust for your child with disabilities, or perhaps your child with disabilities cannot live on their own and will have to live in some kind of other arrangement with assistance. This is something that's part of the planning process and something that we can button up from the beginning of the planning, but also continue to talk about in the years to come. Advocacy and providing for an ongoing system of advocacy is something that not only we need to think about now as we all get older and our children get older, but we also need to think about that at death. Who's going to provide this advocacy? We're going to have to plan for the needs of our loved one. What does that look like 25 years from the time we pass away? We want to coordinate financial planning that has to do with financing this need and coordinating the planning, because What if we today say to ourselves, well, we have X amount of dollars today. We're going to leave X amount of dollars to our loved one with disabilities, but that may not be the amount of money that we have at our deaths. So this is a very tough question, very easy for me to talk about and very difficult to think about. So that's why we need to think about life insurance. That's why we need to have financial planners and financial advisors who can make projections and so forth. We want to protect our loved one from predators and creditors and all of those fraud issues that could happen in life. So we want to talk about that. And we want to talk about the kind of planning, even though it's not the number one goal for most of you. We want to make sure that we preserve assets for other heirs. God forbid, should our loved one with disabilities die. And now, where do those assets go? Well, we can preserve those assets if we plan properly. And so these are the highest and best benefits of planning, just a sample of things I want you to be thinking about. So sometimes in this presentation, you're going to see me be redundant, and I'm going to be going back through certain topics that I've already covered because I'm kind of a believer in repetition, and I want you to kind of get these concepts that I think are more important in your mind in addition to the general information. So we want to have the right team of advisors, and we want these advisors to advocate for your loved one. We want to plan for flexibility. Do we live in a changing world? I think all of us could take a big breath and a sigh of relief and say, my goodness, yes, we do live in a crazy world. A plan without flexibility today, from where I sit here in the office working with clients every day compared to 20 years ago, this idea of having a plan that doesn't have flexibility is just unthinkable to me. So flexibility is a counseling issue. We want to make sure we have flexibility. We talked about the advisory team, the attorney, the financial advisor, the CPA, the insurance specialist, and I'm going to add now to the next bullet point, advocates. These are sometimes called life care managers. There are other titles that advocates have in the world today. Trust protectors. I'm going to introduce you to this topic. For those of you who have never heard of this, a trust protector is a special fiduciary, a person of high responsibility who has a very limited set of powers. Maryland has authorized the use of trust protectors, and trust protectors provide flexibility, and trust protector duties include the right to remove or replace a trustee if the trustee wasn't doing a good job or was ill, or the ability to amend a trust. So we're going to get more into issues about the trust protector as we go through the presentation. Trust protectors are not required, but we certainly recommend that with a special needs plan, that trust protectors are almost what I would consider to be mandatory for the flexibility. Again, I've had parents that don't include a trust protector in the planning, but I would say 98 to 99% of all special needs trusts that we have ever been involved with would include a trust protector provision. So we want to create an effective plan. And as we do that, as I mentioned in the early part of the presentation, we here at Elville and Associates want to give you time to think, time to really consider the choices. What are all the contemporary choices that are available to you today? For example, some of you today have not heard of what a trust protector is. I was meeting with a potential client yesterday, and they were not aware of how the Social Security rules work with regard to a disabled adult child. There are many, many different issues that we're going to get into today, but we want to give you this time to take in all of these things and to be able to make good decisions, because we know what you're up against. We know what you're dealing with in your life just from experience to do what you do to take care of your loved one. Where will your loved one live? We've talked about that. What kind of care will be required? Will they require a guardian or a conservator? Or would we be able to do something lesser restrictive than a guardianship or conservatorship? Who else will be involved in the planning? What outside people could be involved? What kind of lifestyle do we desire for our loved one? What are the challenges we might face? These are things that we could discuss as we take the time to think. Building layers of protection. Remember that what you are doing in your lives right now is you're providing a world you're providing a world of support for your loved one. But after your passing, who will be there for your loved one? And the supplemental needs trust, which we're going to get into, many of you are on the call today to strictly learn about that. The supplemental needs trust is another world that is created after our passing for the benefit of our loved ones. So we're providing that world now, but we want to provide a world of support in the future above and beyond what is available, or hopefully will always be available in the world of special needs planning, or what I meant to say is public benefits. We want to understand the process, and we want to understand the purpose. So that got back to the initial discussion we talked about having a plan, having a process, engaging with a law firm that provides a process and a path forward, and also understanding your purpose. Why am I doing this? And clearly understanding that. One of the most important things I could pass along to you today is the creation of a memorandum of intent. A memorandum of intent is one of the most powerful tools in special needs planning. It's one of the most powerful tools in estate planning in general. What is a memorandum of intent? Well, it is a separate document, a separate writing, and that document, just like these bullet points lay out here, it describes what are your goals and values, what are your expectations for the trustee and for the trust protector and for the advocates. It talks about your loved one's preferences, their eccentricities, their needs, their medical history. This is something I want you to think in terms about. It's not easy to do. Done properly, this is probably a 15 to 20 page document or even more. And I know most of you on this call are used to hard work, so this is not going to be something you're not familiar with. Think in terms of a trustee, God forbid, 20 or 30 years into the future after your death, someone other than who you appointed, changing circumstances, something has happened. This person does not know your loved one. This is a third party. And this person now, the only thing they have is this memorandum of intent that talks about your wishes, your loved one, and all about them and what you want for them and the support that you expect for them. I want you to take this memorandum very seriously, and we will send you a sample memorandum. If you would like one, let Jeff know. We are here to educate and also kind of give you this template to use. You don't have to use this particular template, but we recommend that you consider it. We also recommend that you could create your own. You could have a memorandum that is maybe in the form of a paragraph right inside the special needs trust, or more preferably, you would attach a separate attachment, the memorandum of intent, to the trust, and then you could update that memorandum every 5 years or so. So this helps guide family members, trustees, and so forth, others in the future after you are no longer here. And again, this is possibly, in my opinion, the most important tool in special needs planning. So what should we do today as we start thinking about this process? Well, we want to do all the things we've talked about so far. Think about our purpose, think about our real needs, think about that planning team that we need to get in place. And as we do that, we want to start estimating expenses and what does the future look like? What are the resources that we have to make these projections? So I want to encourage you, for those of you who may not have a financial advisor, I want to encourage you to get one and to interview a few of them so that you can get acquainted with them. Those of you who have a financial advisor, I would like you to take this note down to ask your financial advisor, what special tools do you have that you could collaborate with my team and my attorney to help us understand what our future needs will be? Financial advisors today, as you may well know, and those advisors that are on the line here learning today, they know this, that there are tremendous competition between financial advisors, and that competition has kind of elevated the entire world of financial planning, in my view, and they have tremendous resources available to them. I strongly recommend that you take advantage of those resources. Here is an old school spreadsheet. You may be able to create one on your own or to use one that's different than this, but we want to use financial advisor resources, and we want to understand the financial side of support for our loved one now and in the future. All right, Jeff, I'm just going to stop for a second to see if we have any questions at all. We've been going now for about 15 or 20 minutes.
Thanks, Steve. No questions at this time.
All right, so everyone's being easy on me so far, which is fine, and we're just going to keep going then. Now, we talked about lesser restrictive alternatives. So not all people who attain the age of 18 need a guardianship. I know many of you on the call here may be guardians of your loved one with disabilities, but there are times when a high functioning person with disabilities, and when I say high functioning, I mean a person that has the mental capacity to appreciate the nature of decision making. Now, this is a fluid issue and it's an ambiguous issue many times, but if at all possible, a highest and best practice would be for the loved one with disabilities to sign an advanced medical directive appointing an agent or agents for their health care and appointing agents for financial purposes in a power of attorney and thereby avoiding guardianship. So we want to avoid guardianship where possible. Guardianship is not automatically the right choice for all families and all persons with disabilities. There are many issues to weigh, including whether the person with disabilities is vulnerable, whether they are very subject to fraud, whether they live at home or not. There's many, many different issues. But the bottom line is that for them to execute documents, they must have at least the bare minimum capacity for signing such documents. And that's an issue that's maybe a legal issue that's above and beyond today's discussion. But we want to be aware that guardianship, again, is not always the right choice. Many times it is the only choice, and that's what guardianship is for. It's there for a purpose, but we want to be judicious with it, and we want to understand that it is the highest and most restrictive alternative. Now, supported decision making is something that many of you continue to learn a little bit about. If you haven't heard about supported decision making, Maryland does not have it, unfortunately, but through the efforts of wonderful public service attorneys like Megan Rusiano and others, supported decision making is making its way through Maryland and hopefully will land in the legislature this legislative session, and hopefully it will pass. But if it doesn't, it hopefully will pass in the next 2 to 5 years. If you're interested in learning more about supported decision making, please let Jeff know. I am privileged to be involved in a project that we are looking for volunteers and so forth to help us create a instructional or documentary film about supported decision making. And having said all that, many of you may say, Steve, what is supported decision making? Well, it's the concept that a person with disabilities should be allowed and is capable of making their own decisions or making many of their own decisions and being independent with their right of self-determination, provided, however, that society or the local system of government or we as individuals are willing to provide enough support to that person so that they can make their own decisions. So supported decision making is allowing or helping a person with disabilities through a formal process have a supported decision maker, meaning a person who is going to be their supporter, helping that person make as many of their decisions as possible without the need of a guardianship. It does not replace a power of attorney or an advanced medical directive, and it doesn't substitute for guardianship all the time, but it can be a substitute for guardianship. So hopefully in the future, we're going to have a world where we have the advanced directives and powers of attorney and a person with disabilities being able to officially appoint a supported decision maker, a person to support them. They can do that in writing, and that will avoid guardianship. Now, for those who may know more about supported decision making, there are states that allow even a person under guardianship to have a supported decision maker. So this is a very exciting development in the law that hopefully will pass in Maryland. Our neighbors in DC, the District of Columbia, have supported decision making. Our neighbors in Delaware have it, and several other states, including Indiana, Alaska, Texas, and so forth. So hopefully we will have this, and this is very exciting news for families with a loved one with disabilities. Now we're going to talk about public benefits. Now this is difficult to kind of grasp all this, but I want you to use this as a tool. And remember that if you walk away with basic concepts today, you're going to know more than about 95% of people in the world about special needs planning and public benefits. So don't be too hard on yourself if you don't grasp every single thing that's being said. If I had to give you three categories of how to think in terms of public benefits, I would give you these three categories. There are individuals, like many of your loved ones on this call, who get means-tested benefits. Means-tested benefits is quintessentially defined as supplemental security income, which is slightly over $800 per month. And by virtue of someone getting supplemental security income, which is means tested, they will get Medicaid. So the beneficiary of SSI will get Medicaid. So many of you on this call have a loved one that gets supplemental security income, and as a result, they get medical assistance or Medicaid in Maryland. So that is the quintessential definition of a means tested benefit. Now, many of you know this, but many of you don't, that at a certain time, when you retire or die, your child will transfer or transition, I should say, from being a recipient of SSI to SSDI. And now we're in the middle category. Now, SSDI in and of itself is not means tested. If I were disabled, heaven forbid, and if I had more than $2,000 in the bank, then I still would get my SSDI. It is not means tested. Now, the child or the loved one who transitions from SSI to SSDI is going to be a person who was disabled prior to age 22. We call that a disabled adult child. And that person will now transition at your death or retirement to disabled adult child status. And what this means in a nutshell is that they will receive 50% of your benefit. They won't receive the actual benefit that you received. Your benefit will not be reduced, but they will receive 50% of the amount of your benefit, and they will no longer get SSI in most cases. So this is the transition to a disabled adult child status because they are getting that benefit based on your work record, not theirs. Now, many of you may have a child who has their own work record, and that's a whole different discussion. But this is for the child that doesn't really have their own work record and is going to get SSDI on your work record. As a result, they will get Medicare. So this person gets SSDI, Medicare. Some of you on this call are in this situation. And this is the key now to this second category, even though you won't see it here. This person may also get Medicaid. So here in this second category, the person is no longer getting SSI, they are getting SSDI, Medicare, and Medicaid. So this could be a person who was receiving means-tested benefits not only for SSI, but they might have been in the waiver system, and they are now going to retain their benefits in the waiver system, even though they have transitioned to disabled adult child status. So we've transitioned from the first category to the second. At your death, your child will get 75%. So this is really, really good news for many people who have never heard this before, and it's really quite instructional. So I hope you took something from those last two categories there that we just discussed. Now, veterans benefits and so forth, and Section 8 housing, we're not going to spend a lot of time on that, but I want to educate you by saying that those trusts for beneficiaries who receive HUD benefits, those are the most difficult special needs trusts to administer because any distribution from those trusts for the benefit of the beneficiary could increase the rent of that beneficiary in HUD housing. So we want to be very careful to potentially use an ABLE account to try to get around that problem. And ABLE is the Swiss Army knife in special needs planning, which we're going to talk about at the very end. But these are public benefits at a glance to get you started on the process of thinking through this. Now, those of you who have a pen in your hands or a pencil, or you're on your computer typing, I'd like to give you the name of a book. There are many, many books out there about special needs planning. The one I would recommend, don't be put off by the title, is How to Administer the California Special Needs Trust. How to Administer the California Special Needs Trust by a gentleman named Kevin Urbash. Urbasch. Urbasch. Kevin Urbash. He's the former president of the National Academy of Special Needs Planners, but also he's just a great special needs planner from California. Don't be put off by the title. It's a wonderful book, but I encourage you to read that book to learn more about public benefits. Now, we're not going to talk about the requirements to meet SSI too much, although I will say that if you have a child that's turning 18, let an attorney represent you in the application process so that we can hopefully get from point A to point B as soon as possible without a lot of appeals. This is something for your own benefit to understand what the definition of disability is for SSI and SSDI. We know that the resource test, unfortunately, is very low. A person may not have more than $2,000 in their name. However, many of you don't know this. The person can have a home of any value. Now, that's not saying that they should own the home. Maybe the home 95% of the time really should be owned by the Supplemental Needs Trust. But they can own an automobile. They can have furniture and clothing and personal items, and of course, a burial plot and certain types of life insurance. So a person on SSI, which is the most restrictive, basically, situation that's means tested, that person can still own these things and still get SSI. And Jeff, for our next presentation, we're going to update this. I think in 2022, our benefit is 834, and I should have made that change, so I apologize. For those of you who have the pen or pencil in your hand, I believe the new amount is 834, but we're going to double check that. Now, there are concepts of unearned income and earned income. I was just meeting with a potential client yesterday. We were talking about this issue of what many of you are dealing with. We want our loved ones to be productive. We want them to be happy. We want them to be able to go work and be involved in work programs. However, if they earn too much money, they'll be eliminated from benefits. So we're not going to spend too much time on these formulas today, but just understand that your loved one on SSI could, if they earned too much money, they could be eliminated from SSI and thereby lose their Medicaid. So we want to make sure that if they are working and being productive and happy, we want to make sure they don't earn so much money that their SSI would be reduced to zero. Many of you are providing in-kind support and maintenance to your child because the child or loved one is living with you, and you are providing food and shelter, whereas SSI is supposed to be for food and shelter. So you may be experiencing this 1/3 reduction in the SSI. So there are ways of getting around that so that you can receive the full benefit. But remember that when you provide support to your child on SSI, you will be deemed to be giving them support that would reduce their benefit. SSDI, we're not going to go through this formula too much, but this is for your information. SSDI has certain qualifications. Here, there's a very important slide if you want to make a note of this. This is what we talked about the disabled adult child benefit, the person who is disabled prior to age 22, and there's no resource test here, and they get Medicare basically after 24 to 25 months. And many people in that second category that we just mentioned, many people receive SSDI, Medicare, and Medicaid. Medicaid and Medicare, these are slides for your information about basic information about these programs and who is eligible. Housing for many of you is the greatest concern, and we mentioned this just a moment ago. There is nothing wrong with Section 8 housing. We've actually seen some very nice Section 8 housing recently, for example, in the Rockville area, But just know, as I mentioned before, that Section 8 rules can really cause some problems for the trustee who is trying to administer a special needs trust and is making distributions for the benefit of the beneficiary, who then reports eventually that they're receiving some benefits and then their rent can increase. So we have to be aware. We don't want to discourage the use of Section 8 housing, but we want to be aware of the problems associated with it and what we might need to do to get around those problems. Purchasing a home is wonderful for a person with special needs, but we want to make sure that we understand that the home could be owned in the special needs trust, and probably in most cases should not be owned by the beneficiary, but there are exceptions to every rule, and this is a counseling issue. All right, Jeff, we're about halfway through the presentation, maybe a little bit more, and we're getting ready to talk about special needs trusts. So I'm going to stop and see if there are any questions.
Thanks, Steve. So we have a couple comments. We have some people that are interested in supported decision making, which is great to see. So we'll have to do some follow-up for those ladies and gentlemen. We also have a question that says, can a child who does not qualify for means-tested benefits still receive SSDI after my passing?
That's a wonderful question. Thank you. And the answer is yes. A person, if I'm understanding your question correctly, a child who is receiving SSDI and is not on means-tested benefits, and I'm assuming what you're meaning is that child is in that second category, let's say, yes, they will continue to receive SSDI even if they're not on means-tested benefits. So just because they're in that middle category does not mean that they must be in a waivers program or receiving other means-tested benefits. Thank you for that question.
Okay, thank you. And another person thanking you for the great explanation about SSDI versus SSI. And then we do have a question about, let's see here, I apologize, I just lost it. And we have a question here saying, there are many families who do not understand. Please have Steve repeat the SSDI and 75%. Can you explain that? Do you understand that?
Yes, thank you so much for that. I did kind of say that at the very end, the tail end of that discussion. So let me just go back to that middle category again. So what is very instructive for many special needs parents is that their child, when they are considered a disabled adult child, they were disabled prior to age 22, that child upon your death or retirement, I should just maybe reverse that, your retirement or your death, will begin to receive, instead of SSI, the disabled adult child benefit, which means they will get 50% of the amount of your award for Social Security, and that's during life. And then at your death, they will receive 75% of that amount forever. So this means they are no longer on SSI. They are receiving at your death 75% of the amount of your Social Security award, and that is permanent, that's forever during their lives, and hopefully that is the explanation.
Okay, thank you. And two more. I just retired, but I'm not planning to take my Social Security for 4 years. My son is currently on SSI. Will he transition to disabled adult child status now upon my retirement, or not until I begin to take Social Security?
That's a great question. My understanding is that it will not happen until you begin to take your Social Security. But I will double check that. If you will please send Jeff, if you haven't already, send Jeff your email and we'll get back to you with the answer to that. But I believe it's going to be when you take your Social Security.
Okay. And then last question is, what about those who qualify for, quote, dual benefits?
Well, I'm going to try to extrapolate on that question. I believe you might mean that a person who would qualify for Medicare and Medicaid, that person, as we are going to see with the special needs trust here, will still be the person who needs a special needs trust for various reasons. If we are developing a special needs trust to protect the public benefits or the means tested benefits of our loved one, even when they transition to disabled adult child status, because even though they're receiving Medicare, they're still going to receive Medicaid. But in addition to that, let's say they are receiving means tested benefits, meaning a waiver program benefit or other benefit that even though they're no longer on SSI, hopefully what I'm answering here for you correctly is, hopefully your question was, what about that person? Well, that person is going to continue to receive their means tested benefits because in that circumstance, you're going to keep their assets below $2,000. And therefore, at your passing, that supplemental needs trust is going to not affect that person's benefits because even though they're in that middle category, they're still continuing to receive means tested benefits. If that was not the nature of your question, please let me know.
Okay, and I think that's all for now, Steve. Thank you.
Thank you, Jeff. And before we go on, I just wanted to ask again the audience to let you know that if they would like to receive a memorandum of intent, a sample memorandum of intent. All right, so now we're going to go into special needs trust, which I know what many of you are on this webinar for. So let's get right into this. The bread and butter of special needs planning is the third party trust. So I want you to think in terms, we're going to show a graphic here in just a minute, but I want you to think in terms of a trust, and that trust can be inside of your will or your revocable trust. This third party supplemental needs trust can live right inside there, or it can stand on its own. It can stand on its own, and perhaps it should stand on its own. There are many reasons why perhaps you would have this trust stand on its own. Perhaps you're going to fund that trust during your life. Or perhaps you have a relative who has been waiting for you to set this trust up because if they die before you, they want to leave assets to the trust for your loved one. So the third party trust is the bread and butter. Anyone can establish that for their loved one, meaning any relative. The grantor can control. So in other words, at the death of the loved one, God forbid, the person who establishes this trust, let's say you can control where this trust is distributed to. So it could go to other relatives. There is no payback. So the third party trust is very flexible. It's designed to create that world for your loved one that we've been talking about. But at your loved one's death, if there's anything in that trust, those assets are going to be distributed to the beneficiaries that you designate and not to the state of Maryland. So that's the bread and butter, the third party supplemental needs trust. That's what parents and grandparents and others establish as part of their own estate planning for the benefit of the loved one. It can be funded during life, or it can be funded at death, or both. Now, the second category here is what we call the D4A trust. This trust is under the United States Code. I'll give you the brief definition of the code or the reference. It's 1396P D4A. So it's 42 USC, 42 United States Code, 42 USC 1396 P D4A. And that's where this trust is found in the federal code. It's also in the Code of Maryland, the COMAR. This is what I would call a utility trust. This is the kind of trust that we're going to see in a few minutes that is used if your loved one were to receive monies that they should not have received. It disqualified them from benefits. Fortunately, if they are under 65, this money can be taken out of the loved one's name and put into a D4A trust. We call this a first party trust. In this sense, the loved one has received money themselves. They've received money themselves that they should not have, and we need to get it out of their name. So thank goodness this trust exists. But as you see on the far side of the chart here, this is a Medicaid payback trust. So at the death of our loved one, this will be paid back to the state of Maryland to whatever extent it has It has to be, to whatever extent there are funds there. Now, this can be established by a parent or grandparent or a court or a guardian. And notice here at the end, it could even be established by the beneficiary, someone who is high functioning, who can establish their own trust. President Obama authored legislation, or his administration passed legislation that basically allowed a special needs beneficiary to do this. Now, if the person is over 65, another first party trust is called the pooled trust. Now, the pooled trust is for, in my view, someone who does not want to have a D4A trust drafted if the beneficiary is under 65 and wants to have more of a streamlined approach. But this is also a payback trust, so we have to be aware of that. Now, it does have utility. For example, I had a situation this past week where someone is almost 70 years old and they have a significant amount of money coming to them, or it's going to be in their name soon, and that person is going to need to get rid of that money out of their name, and they are over 65, so they're going to have to sort of dump this money into a pooled trust so that they can be eligible for benefits. So the third party supplemental needs trust is really our focus. The D4A first party trust is the tool for someone who receives too much money, someone who receives an inheritance they're not supposed to receive, someone who is injured in an accident and receives a large tort settlement. The pooled trust is a tool. For example, the Arc of Northern Virginia is a pooled trust, or First Horizons is a pooled trust, okay, or Maryland First Disability Trust. So we want to be aware of these tools, with the third party trust being our focus. So the third party trust is the best one. That's the one that we want to establish during our lives as part of our estate planning. It is called a third party trust because money or funds are coming from a third party straight into the special needs trust, and it is not going to your loved one. Now, why do people do these things? Well, probably they are not educated and they make mistakes. You will not make these mistakes. So we don't want to do these types of arrangements. We don't want to give an outright inheritance to someone on means tested benefits. Obviously, we don't want to do that. That would result in the loss of SSI and Medicaid. Or we could leave assets in a non-qualifying trust. For example, you're not going to believe this, but I have seen trusts where the person thought this is a special needs trust, but it really isn't. It was a general needs trust. It was what we would call a support trust. So remember that assets could be left in a general needs or support trust, for example, a health, education, maintenance, and support trust. And we know that a special needs trust cannot be a support trust. A special needs trust must be a discretionary trust. So we don't want to leave assets in a non-qualifying support trust. That would result in the loss of SSI and Medicaid. Now, some people say, well, I'm just going to disinherit my child and that's going to take care of that. Well, we don't recommend that. And the reason why, even though sometimes it's tempting to think about this, well, we're going to leave assets to brothers and sisters, siblings, who will take care of my child. And of course, each of your situations is different, but think about this. If we leave assets to a sibling, the assets then become subject to the sibling's creditors. So the sibling could lose the assets to a creditor. What if the sibling dies, or the person who's left the money dies? And what if their estate or their will or their trust controls the assets and leaves it to someone else? What if they decide they don't want to take care of their sibling and they want to have their own family and don't want to do it anymore, but they still have the money? Or it could be lost in a divorce, and unfortunately we could go on and on. It could be lost to a tax lien. There are many different ways that this money can go askew. So we want to make sure that we don't go into these self-help type of arrangements. Now, the third party trust, the beneficiary can't create the trust. It doesn't hold any of the beneficiary's own money. Now, we can't put SSI money in there. We can't put SSDI money in there. There are ways to get that money from point A to point B to point C back into the trust, but we can't put SSI or SSDI money of the beneficiary directly into a special needs trust or supplemental needs trust. And the beneficiary, of course, cannot be the trustee. So there are no payback requirements. It can be revocable during your life. So one of the things that we do these days is create these trusts where they're very, very informal in the sense that you can decide to fund them during life. And if you do, you don't have to file a separate tax return and so forth, and the trust can be revocable until the time of your death. This gives you more flexibility during your life. But there are times when trusts are funded during life, if you ever decide to do that, and they're funded in such a way that there's a lot of money in there and it really shouldn't be revocable. So we have to just walk through this as a counseling issue. Now, one of the big considerations in special needs planning is choosing trustees. This is a paramount issue. So we want to be thinking about this. Should it be a family member? Should it be a professional? Should it be an attorney? And there's lots of considerations here. Jeff and I basically produce a webinar that we've done in the past several times called How to Choose a Trustee. And Jeff can make that link available to you if you have questions about this. But all of these factors have to do with the correct selection of a trustee and various selections of successor trustees. So we want to make sure we've not only thought about our trustee, but our successors. And as you'll see in just a few minutes, the trust protector is a tool to make sure that we have flexibility due to changing circumstances in the future with regard to the trust, but also with regard to trustees. Now, we've talked about using a trust protector. Let's talk about a trust advisory committee. So a trust advisory committee is simply a provision in a supplemental needs trust telling the trustee that if they have an issue of a very big magnitude, this is an issue that they can't resolve, it's troubling, the beneficiary is having issues, God forbid, the trustee needs to call a committee together. The committee could be a psychiatrist, the family doctor, a social worker, a service coordinator. It could be any of those people, an advocate. Now, could the trustee do this even if we didn't provide this in the trust? And the answer is yes. But unfortunately, many trustees don't read the trust or they don't really understand their duties. So in the trust, what we try to do in let's say best practice estate planning or special needs planning is we want to name all of the potential things that practically speaking, the trustee can do so that they are aware of it. This is one of those optional features. Now, perhaps more importantly is the trust protector. We talked about that earlier. The trust protector has the authority to make modifications to the trust. For example, the trust protector needs to change the trust provisions because the special needs laws, the Medicaid laws have changed. The trust protector needs to make changes to the document because the tax laws have changed. The trust protector needs to amend the trust because the Secure Act, which many of you may have heard of, allows for someone with disabilities or chronic illness to be able to maximize the tax deferral of the stretch out of an IRA. And we want to make sure the trust always remains eligible, an eligible designated beneficiary for Secure Act purposes. So that might be a reason the trust protector needs to make a change. The trust protector can review accountings. The trust protector provides flexibility, but this is one of the big ones. The trust protector has the right to remove and replace trustees. So many of you, if this is the first time you've heard about a trust protector, this takes a little bit of getting used to, but I strongly encourage you to think in terms of who would be the person to be my trust protector, the person who has the authority to tell the trustee what to do, to direct the trustee with regard to these issues. And this ideally would be a person who is not a family member, an independent person, so there's no conflicts of interest. But with that said, in special needs planning, I occasionally see a family where there just aren't any good choices for trust protectors other than family members, but ideally this will be a non-family member. Now this is I guess the circular view of what a trust looks like, a special needs trust in my mind. and the special features of a special needs trust today, or what I should say, the ideal features of a supplemental or special needs trust. Now, I'm going to stop right there for just a second. Those of you who have been listening here on this call know I've used these terms interchangeably. I have used the term supplemental needs trust, and I have used the term special needs trust. Now, for purposes of our discussion, it probably doesn't matter much, but here's the technical answer for those of you who have been wondering about this. A supplemental needs trust, like the third-party supplemental needs trust that I've been talking about, that is the correct name for a third-party trust that you create as part of your estate plan. It's basically supplemental in nature as a discretionary trust for the benefit of your loved one. A special needs trust, defined, is a first-party trust, the first-party type of the D4A trust or the D4C trust. But if we use the terminology special needs trust, I think we all know what we're saying, but technically speaking, the supplemental trust, the supplemental needs trust is the third-party trust. The special needs trust is the government sanctioned trust, the D4A or D4C trust, and those trusts are considered to be what is called sole benefit trusts. So that's the distinction. All right, getting back to this circle now, which represents a supplemental needs trust or a special needs trust, we have the trustee, of course. We want to be very careful with our selection, and we want to have flexibility for the future. We want to be equally careful with our trust protector selection. You could even name trust protectors and also name a person who has the authority to remove a trust protector. So lots of choices that are part of the counseling process. An ideal provision in a supplemental or special needs trust is Maryland Able. That, now I'm going to make the distinction here. The supplemental needs trust really has the authority for the trustee to be able to fund a Maryland Able account. So Maryland Able provision would be in a supplemental needs trust. An advocate, we want to encourage the use of advocates. If you're a person who's over 50 or 60 or even 70 and you have a special needs child, now is the time to perhaps start to introduce advocates to your loved one. The memorandum of intent, we want to have that as part of this ideal planning. The trust advisory committee, and then special retirement plan considerations. We talked about the Secure Act just a little bit. We want to know that there are only 5 categories of people who are eligible to be exempt from the Secure Act. Many of you have heard that in 2020, January of 2020, the Secure Act came into law because President Trump signed it into law, and it does not exempt 98% of people in this country who, when we pass away and leave our retirement plan assets to our loved ones, those loved ones who receive inherited IRAs will only be able to stretch out those IRAs for 10 years instead of their lifetimes. So the good news is that people with disabilities and people with chronic illnesses are two of 5 categories of people who are exempt. So your loved one with disabilities is exempt, their supplemental needs trust is exempt, and we want to make sure that we have the proper retirement plan considerations for those of you who have a lot of your funds in retirement assets that are going to come to the supplemental needs trust. We want to make sure that we've covered our bases there. Trustee duties include all of these things in these concentric circles. Jeff looked high and low for people who he thought were perfect trustees, so he got their pictures here. These people are wonderful. They understand accounting. They keep accurate records. They keep the beneficiary informed, which is one of their statutory duties. They comply with everything. They're financially savvy. Now, they don't actually make the investments themselves, although they could. We don't recommend that. They understand taxes, they understand investments, but they do what? They hire professionals. They want to be doing their highest and best fiduciary duty, and unless they are professionals themselves in the tax world or in the financial planning world, they should not be investing the funds because they have a fiduciary duty. Advocates, they are wonderful advocates. They always advocate for the best interest of the beneficiary. They understand public benefits and they promote independence and quality of life for the beneficiary. So these are the perfect things that we want in a trustee. And if you look at the link for the trustee selection workshop, you'll also have further tools to be thinking about these things. A supplemental needs trust is very broad in what it can pay for the benefit of the beneficiary. Special needs trusts are more regulated because once those are established, and it's not hard to establish them, but once they're established, there are annual accountings that have to be given to the state of Maryland. We can send you a list of what a supplemental needs trust can pay for. Just remember that in a supplemental needs trust, we can spend things on a little bit more broad basis. With a special needs trust, we are more regulated because it's a sole benefit trust. But for purposes of today's workshop, I just want you to think in terms of anything that would be distributed for the benefit of a beneficiary that is routine and usual for them, for their benefit, is just something that would be authorized from a supplemental needs trust. We talked about this a little bit. How much should we fund? So there are basically various family situations, various asset situations. This is where I want you to really collaborate with your advisory team. How much should we fund into this supplemental needs trust? In a perfect world, we would all establish a supplemental needs trust during life, and we would fund that during life. Why? Because we don't know how much we're actually going to have at death. So life insurance is a very powerful tool. And we want to think in terms of funding the trust, which many times gets a little bit glossed over because many of us don't want to think in terms of, well, I may not have as much money in the future as I have now. Hopefully you'll have more, but think about it at the time of our deaths, how much will be there to fund the trust. So we want to think about tools, using the services of financial advisors, and making projections and using life insurance where it's appropriate. And life insurance, again, especially permanent life insurance, even though it's expensive, it's a very powerful tool. We talked about the first party trust. Now, this is the tool that we use when someone's eligibility has been threatened because now they've received money they should not receive. So this is an approval by the Attorney General. This is not a hard thing for us to do. We can get the approval of the Attorney General for one of these trusts pretty easily these days, but the trust has to be approved, and it's usually from a personal injury award. God forbid when someone is in a train accident or a car accident and they receive $5 million settlement or a birth injury. These are the types of funding that go into a first party trust, the D4A type, but it's also when our child receives an inheritance they shouldn't have had, or they somehow obtain money that knocks them off of their benefits. Now you'll notice at the bottom here, and this is a lot of information today that I'm throwing out at you, this is something that's an ideal thing to put in place with the third party supplemental trust. So in other words, you can create a first party trust now so that if your child ever receives money they shouldn't receive, or receives an inheritance from a well-meaning relative, or just simply has too much money in their name, which happens quite often, that first party trust has already been approved and it's already sitting there and it's ready to be funded. So this is a best practice, although you certainly don't have to do this as part of the basic special needs planning. So again, best practice would be to have a third party trust as part of your estate planning, and also have the first party trust already approved by the Attorney General. It doesn't cost very much money to do that. We draft that up. It gets sent to the Attorney General, and there's no charge for that sending and approval. And now we have kind of the best of all worlds with our trusts. Now, at Elville and Associates, I'm sorry for this wild graphic, but at Elville and Associates, we have a process. We talked about purpose, we talked about education, but we also talked about the need for a process. So I just want you to know, for those of you who are implementing a supplemental needs trust or planning for the first time, we do have a planning process. Our basic estate planning process is a little bit different than this one, but this is the process for special needs planning. And if you can follow this clockwise, this will show you that we do have a methodical process of education and collaboration. And this is a more straightforward view of that graphic for your information. Part of guardianship consideration, again, is an assessment of, do we have supported decision making, which right now we don't, but we hopefully will. Is that part of our world? Is that something that we can implement? Does our loved one have mental capacity? Are they vulnerable? Are they subject to fraud and abuse? What is their status in life? What is their family relationships? So these are broad questions. Guardianship should be implemented where the person is vulnerable and does not have the mental capacity to appreciate the nature of their decisions. And many of you are going to need to get guardianship simply to have HIPAA clearance, to be able to have information on the medical records of your child. So just know that this is a big issue. Guardianship of the person is what is most commonly implemented when we have a loved one with disabilities. Most of the time, guardianship of the estate, or what we call guardianship of the property, is not implemented unless that loved one has assets in their name above and beyond Social Security. Many of you are the representative payees for your loved ones, and therefore you don't need a guardianship in the eyes of the court. But if your loved one has assets above and beyond SSI money, then we may need a guardianship of the property. So what should you do? Well, again, we want to give you a path forward, not just tons of information, which hopefully was helpful to you today. We do not charge for special needs planning or estate planning consultations. We would just give you an estate planning questionnaire to think through and to complete, part of your homework, in addition to the letter of intent or memorandum of intent, and in addition to any other links for information that we can send you. We want to encourage you to relax, that there is nothing to fear. It is a strange thing to think about consulting with someone about these incredibly important issues and sharing your personal information with someone you've never met before. But we want to encourage you to relax. There's nothing to fear. Here at Elville and Associates, we have 3 major conference rooms. I'm in conference room 1 here in Columbia, looking outside today at the snow. But there's nothing here to fear, and we have an environment where everything is confidential and it's quiet, and you would have a chance to really think through things. We want you to bring your current estate planning documents for review. For those of you who have planning or have current wills or trusts or a special needs trust, supplemental needs trust, please bring that so we can review it. We don't charge to review documents. We also want you to have questions, concerns. Write them down, type them up. And if you don't want to write them down or type them up, that's perfectly fine. But we encourage you to use this opportunity to really ask questions that you may have had for many years that you need to have considered or that you're concerned with as part of your planning. We want you to consider an advisory team. And if you don't have one and you'd like to interview people, we are glad to give you recommendations. I've been very privileged to train financial advisors for many, many years, and I know many of them are wonderful, and you simply have to just avail yourself of their services and their time. And again, we want to give you time to think. We have 6 attorneys here at Elville and Associates and 2 special counsel attorneys. Here in Columbia, we have approximately 20 employees. All of us are dedicated to education and to making sure that you get your questions answered and to taking care of your client, of your family members. So what do we want to do further? Well, we want to create a memorandum of intent, as I mentioned, establish your own estate plan. As part of that plan, establish a special or what I'll call a supplemental needs trust, either inside your will or trust or standing alone. And we'll talk about in our meeting, if we do meet, we'll talk about the difference between those two. We want to talk about the financial considerations, especially the Secure Act and how that will affect the supplemental needs trust. We want to understand public benefits. We want to ensure that our trustees are educated. Here at Elville and Associates, you'll notice when you look at the process that we always set aside time for a family meeting. So if your trustee is so inclined and is willing, and you want them to be educated, we're here to educate them in a family meeting as part of your planning process. We want to think in terms of advocates. If you need names of persons who might be willing to advocate for your loved one as a professional advocate or life care manager, we are happy to give you those people's information. And of course, we want the special needs to be part of your estate plan. So as I wrap up, I just want you to be aware that right past this slide, we have some information on Maryland Able. We are very privileged to have presented many times with Maryland Able and to be a part of or have them as part of our repertoire, as we want our clients to have access to much information. So many of you on the call are interested in Maryland Able. Here are some slides at the end for you. But I thank you for your time and attention. Jeff, it looks like we've gone about an hour and 15 minutes, a little bit more than that. And hopefully we've left plenty of time for questions here at the end. And I want to thank everyone. Jeff, I'll let you take it from here.
Well, thank you, Steve. A lot of information and very well presented by nobody better than Steve Elville to start off the year. And I made this topic our first presentation because to us here at Elville & Associates, special needs planning is so very important. And we're very passionate about it. And I could think of no better topic than to kick off 2022 than what families need to know about planning for a loved one with special needs. So we're going to start off with some questions here. We do have a number of them, Steve. So let's go ahead and jump into them here. We've got a little bit of time. And before I go into those questions, and then we'll wrap up, I have a lot of follow-up to do for you. As many of you hopefully know that you've been on the webinars, I try to provide a very substantive follow-up email after our webinars, no later than the morning after our webinars. So I have a lot of links to send to you, a list of what our supplemental needs trust can pay for, a link to a number of our other special needs planning webinars, supported decision making, the ABLE webinar, how to choose the trustee, a link to the Kevin Urbash book, and a few other things. So I'm going to give you a long list of information that hopefully is going to be very helpful to you. And I'll make sure you have that no later than first thing Monday morning. So I'll be sure to get all that information to you. And there were a couple of people that were interested in the supported decision making specifically, and we will follow up with you personally and gauge specifically what you're interested in learning about. And we appreciate your interest, as that's something we're very passionate about here at Elville & Associates. So thank you. So with all that said, let's answer some questions. So first question, if I wait to receive my Social Security benefit until 70, would my child get 50% of the increased amount?
Thank you. Yes, my understanding is that definitely would be the case. So the question that was asked earlier about when the benefit would start, I'm going to double check that, and the answer being what I think it is, that it would only start upon the time you receive your benefit. That would be true, that the 50% would be of that particular amount.
Okay. Next, can an adult disabled child who receives SSDI based on my ex-spouse's Social Security benefit, which is greater than my SSI benefit, will the child SSDI benefit stay the same as my spouse's death or be reduced based on my lower Social Security amount? Thank you very much.
Yes, thank you for that question. That is a question that I will have to research. If you will please give Jeff your email address or phone number. I don't know the answer to that question. I think that it could stay the same because that's what it was based off of from the beginning. In other words, your ex-spouse. But I want to give you a definitive answer on that. So I will get back to you on that. Thank you.
Okay, and I do have your email address, and I will copy the question down, and we'll take care of that and get a response to you.
Thank you.
Let's get to the next question here. And we will get the memorandum of intent out to everybody. Got quite a few of those requests. Okay, a number of those requests. Okay, one more question on this topic. Steve did not explain how it is determined whether the disabled adult child continues to receive Medicaid once they transition to Medicare.
Thank you for that question. So where I was going there is that this is going to depend on what means tested benefits were being received before. So let's just say a quintessential example would be a child who's receiving SSI and is in the DDA system. So SSI is means tested, DDA or waiver benefits are means tested. And now the child transitions from an SSI status to a disabled adult child status, and you as the parent and of course the child make sure that the child's assets remain under $2,000 because now there's been a transition, but the child is still receiving medical assistance and as a result is in the Medicaid system, and ergo the child is in the DDA system because they were in the system prior to age 22 and so forth. So my point there is that the child who receives SSDI, Medicare, and Medicaid, that beneficiary, that person is in the same situation for purposes of means tested benefits. They're still basically in the same situation as they were when they were receiving SSI, except they're no longer receiving SSI. And therefore, when you die and their supplemental needs trust is funded, their means tested benefits are not going to be affected, but they are in just as much of a need for a supplemental needs trust, not for many other reasons possibly as well, but they are in just as much of a need for a supplemental needs trust as the person who was on SSI because they didn't want to lose their means tested benefits either.
Okay. Thank you very much for that, Steve.
You're welcome.
Next question. Are trust protectors allowed in a non-special needs trust like a generation skipping trust?
Yes, that's a wonderful question. The answer is yes. So there are ways these days to change a trust. So if you already have a generation skipping trust and it's already in existence and it's funded, there are ways to actually change an irrevocable generation skipping trust to include a trust protector. If you are just creating a generation skipping trust now, definitely trust protectors are allowed and highly recommended because in Maryland, for example, a generation skipping trust could last forever. There's no limit on the amount of time that a trust can last. So definitely the answer is yes.
Okay. You mentioned pooled trusts. Are they by definition always first party trusts?
Great question. The answer is yes. Pooled trusts, which are called D4C trusts, those are always by definition first party trusts.
Okay. And another question, good question. Do you provide consultations by Zoom?
Yes, thank you for that. We do provide consultations by Microsoft Teams or Zoom, whatever platform is best, and we also do telephone consultations.
Yes, very good. So we have a comment here. I will get my stuff and questions together in the next few weeks and would definitely like to schedule an appointment. Steve is excellent. Well, thank you very much.
Thank you, sir or madam.
And that's from Larry. Larry, I spoke to you several times over the past few days. Thank you very much for that. We appreciate that. Look forward to meeting you. There's several, I'm sorry, I'm just waiting through the requests for different links and memorandums of intent. I will send all those links and the memorandums of intent out to everybody, so you will get all that information. Another one, so just bear with me here.
Glad you're being put to work here, Jeff.
Yes, yes. So this is very interesting. We've been thinking about this recently, and the webinar came at a good time. Well, great. I'm very glad. We do offer this webinar about once every 2 months. So if you have somebody that's interested, please let them know. They can always join our mailing list, or they can check out the video that I'll be sending. You can share that video with anybody that you'd like. Live is always great, so you can interact and ask questions, but you can always share that video with anybody you'd like. Let's see here. Okay, so we do have a question. Here we go. To summarize my 2 questions. Number 1, are trust protectors allowed in a non-special needs trust? Oh, like a generation skipping trust, we just answered that. And 2, can an adult disabled child who receives SSDI based? Okay, I think we just, so that was the gentleman just summarized his 2 questions. You answered the first. There was the second one, which I already have in an email to you to confirm. So we'll get that confirmed. Okay, very good. Thank you for that, sir. Larry. We'll get to a question here, I promise. I was told that the child will get 50% of the amount due at full retirement age, not at age 70.
Wait, yes, and where I'm going with that is the question that I was trying to answer was, when a person takes Social Security, is it based on the amount at that time? And that's what my understanding is, but I will verify that.
Okay. Can cash surrender value of my autistic daughter? Okay. Let me try to interpret this a little bit. Can cash surrender value of my autistic daughter be considered as cash?
Yeah, so if I understand that question right, cash surrender value, I'm assuming you mean of a life insurance policy or an investment account?
I would assume so, yes.
Yeah, so if that's the case, yes, it would be considered cash. That would be in your child's name. And if life insurance cash value exceeds $1,500, it would be a countable asset for cash as far as Medicaid is concerned. So we'd have to know a little bit more about your question, but yes, I would like you to consider that as an asset that could potentially put your child over scale for SSI and cause issues.
Okay, that's a question from Waddy, Steve.
Oh, okay.
Okay, next question. What are the considerations around giving a sizable gift to a special needs trust and activating it now rather than at the time of the parent's death, so that there's more time for the assets to build at a higher rate of return than the parent's current asset allocation for retirement, which could continue for 20 or 30 years and become more and more conservative?
Yeah, thank you for that excellent question. So a lot of things going on there in that question, so I'll just try to touch on some of them. There could be a consideration here for just getting certain assets out of your name now. So let's say that you just felt emotionally and psychologically, it makes me feel good to just set aside this amount of money. We've earmarked this money. I want to go ahead and get that in the supplemental needs trust. Nothing wrong with that. Someone who might say, well, I'm going to make a large gift because for estate tax purposes, I want to get this out of my name. I want to use some of my estate tax exemption and get this as a completed gift into this trust, whatever the situation may be there. There are ways of just making the trust revocable, okay, so that you don't have to file a special tax return called a 1041 every year. But on the other hand, if you're going to make a large gift into that trust, it may be more advantageous, especially if we're making that a completed gift for various reasons, it may be more advantageous to make it an irrevocable trust. And remember, even with an irrevocable trust, there are ways to still have flexibility and be able to change the trust if necessary in the future. So it depends on what we're trying to accomplish there. It sounds to me like you're trying to earmark funds, get them set aside, and consider those funds gifted and let those funds grow. And I don't think there's anything wrong with that. Every person's situation is different, whether that gift is tax related or just special needs related, where you just want to get it out of your name. It sounds perfectly fine to me, depending on what your purpose is there.
Okay. And we are at 11:30, but we do have a few more, so we'll wrap those up here. A good question. If our estate documents needed to be updated, does it make sense to engage with your firm if we used a different lawyer in the past?
That is a wonderful question. Thank you. Well, I want to be fair to the other lawyers. So let's say that you have dealt with other lawyers in the past and you were happy with them. We have a situation right now where we are helping another law firm update documents. Now, of course, we feel strongly that we are going to provide all the necessary paths and the counseling and so forth. But if you have documents that you have and you've worked with another attorney in the past, and you feel that the other attorney is going to do some of the things that we're talking about here, then there's nothing wrong with staying with that attorney, to be honest with you. Now, if you feel you have that special relationship with that other attorney, which is very important, it's important to feel good about who you are engaging with as an attorney-client relationship. If you feel very good about that, but you doubt that they might be using some of these techniques, then we're happy to work with your attorneys to help them update your documents, if that doesn't sound too awkward. We do that occasionally. So I think that's a wonderful question. It's just a question of the relationship that you have with them and whether you should start a new one or not. Thank you for that.
Good question. Is it a good idea to have a financial planner just for my adult special needs daughter? It gets confusing to find a planner that can advise for me as working retired and my daughter's financial needs.
What a wonderful question. I never have had that question put that way, and I want to thank you for that. I would say that yes, it's very possible that your conventional or regular financial advisor, maybe what you're saying is they really don't have any specialized knowledge about this particular area, but they do a wonderful job for you, and yet they may not have the tools and resources or even think in terms of those tools and resources for special needs. So I do think, having heard that question, that it is possible to have two different financial advisors. Many families don't have a financial advisor at all, and then they can't find a financial advisor who understands their needs as a special needs family. So they tend to gravitate toward one financial advisor for everything for that family. But I think based on what you're saying, yes, definitely you could use a financial planner for the special needs of your daughter, someone who has tools and resources and understands that, versus your general financial planner who you're very happy with for what they're doing for you. I think that is reasonable.
Okay, very good. And the last comment, our friend Wadi was just confirming that he was alluding to the cash surrender value of life insurance and the Gerber grow up plan, actually. So,
Understood.
And
Okay.
thanking you for answering the question. So
All right.
those are all the questions and comments. We'd like to thank you for a great webinar and a great start to our webinar series for 2022. Thank you for your participation, and thank you to Steve for your time and your expertise as always.
Thank you, Jeff.
We look forward to seeing you again very soon. We have a great start to January, a lot of great webinars in place, including our wellness series next Tuesday, setting health goals for the new year. We've got a great webinar set for that next Tuesday at 1:30. I hope you can attend. Check out our events calendar on our website, elvilleassociates.com/events, and you can see all the webinars for January. We hope you can attend, and we look forward to seeing you again soon. So have a great Friday and a great weekend. Have a great day. Thank you.
Thank you.